The Ontario Parole Board is dedicated to the process of promoting public safety by making responsible decisions regarding the return of offenders to the community through supervised conditional release. Parole is the early release of an offender from a correctional institution that is supervised by a probation or parole officer. Parole provides the opportunity for offenders to serve the remainder of their sentence within a community under the conditions set by the Ontario Parole Board. The Ontario Parole Board conducts parole hearings to determine if an offender can safely reintegrate back into their community.
Let's talk about the application process. To apply for parole, you must first become eligible. To become eligible, you would have had to have served 1/3 of your sentence. So, for example, if you have been sentenced to 1 year, you would have had to have served 4 months to become eligible for parole. This is known as the parole eligibility date. However, anyone who has served 181 days, that is 6 months, will automatically be considered for parole. If you have been sentenced for less than 6 months, you are going to need an application form to be considered for parole. If you have been automatically considered because you have served 6 months, a member of the Solicitor General staff will provide you with an application checklist, and then you will decide if you want to apply. If you choose not to apply, you can waive your parole consideration entirely by selecting option 2 on the waiver form. But if you do decide to be considered for parole, but do not want to have a hearing, you can go ahead and select option 1. In this case, the board will make a decision based on the submissions and the information in your file. In both instances, however, you as the applicant have the option to change your mind and have a hearing be scheduled by the board. If you decided to be considered for parole with or without a hearing, the board will require relevant information to be submitted before parole consideration begins. If you have opted in for a hearing, however, you can make these submissions during the hearing. The information for submission can come from the victims, the applicant's file, a support person, or a medical support person, just to name a few. The hearing will then commence on a date before the parole eligibility date. Who can attend the hearing? The parole board is unlike the traditional tribunals in terms of its rule of evidence and its procedures. Unlike a typical tribunal, cross-examination is not done in order to gather evidence. So the members who can attend a parole board hearing includes the applicant, the victims, the applicant support person, the victim support person, a translator if needed, and a staff member from the Solicitor General office. If a member of the public wants to attend the hearing, an application is required. The application will be assessed based on the effect public knowledge may have on safety or the applicant's ability to reintegrate into society, and general security risk, among other factors. An observer can fill out the application and have it assessed by a member of the Solicitor General staff.
Hello all, my name is Ibelina and I'll briefly walk you through the parole hearing process and motions. The hearing will be conducted by the Ontario Parole Board through media applications known as electronic hearing over the internet, or may meet the applicant in person to review, or might review the paper file and make a decision. And during the parole hearing, the submissions from applicant or the assistants are heard by the members, and the board reviews all information to ensure that it's relevant, reliable, and persuasive. The hearing is conducted by a minimum of 2 board members and the applicant with other parties, but only with permission. The applicant will have to explain to the board the reasons for applying for parole and discuss details of the offense, criminal record, release plan, and so on. Recommendations made by the trial judge and public prosecutor is considered, while the written or oral statement of the victim or the victim's family submitted to the board is also focused on. The applicant or his assistant makes submission at request and answers all questions asked by the members at hearing. Primarily, all questions are related to a varied numbers of factors when deciding whether to grant parole or decline it. Before the hearing is wrapped up, the board may ask for any final submissions from the applicant. After submissions and questioning, the board gives out the decision along with the reasons, or may decide to give out the decision later between 1 and 5 business days. The applicant will receive the decision in writing, and whenever parole is granted, there are some conditions attached to it. So the applicant will need to follow once he is out on parole. Otherwise, his parole may be revoked. The motions in a parole hearing. Applicants may bring in a motion requesting the board to resolve an issue in their case, questioning a procedural issue, or simply to make a change in any order given out by completing the option 1 hearing and parole consideration waiver form. The applicant can revert back to a hearing by notifying the board in writing. Another motion that can be brought in the boards is a waiver option 2, waiver of parole consideration. This is done by completing the option 2 of the hearing and parole consideration waiver form. The applicant can revert back to a hearing by notifying the board in writing. Under exceptional circumstances, the applicants can make a motion for earlier release ahead of the parole eligibility date. A motion to change a parole condition can also be made by preparing and filing the special parole report with assistance from a parole staff and submitting it to the board. Any motion to revoke or suspend parole can also be made by the applicant with a written request to the board. This has to be made to the same panel of members who granted the parole decision. Request for review of parole decision is filled by an applicant who wants to challenge a decision of the board. Request for new hearing can be made by an applicant in writing on grounds of incorrect review, wrong or inadequate information, or unreasonable decision by the board.
If an applicant feels like they have received an unfair decision, there's a form that can be submitted named the Request for Review of Parole Decision form. Their legal representative can also do this for them as well if they are unable to do so. There's also going to be other materials that are reviewed, such as audio recordings and such, that are on the applicant's file. The board will give the decision to the applicant in writing due to the review and the decision, as well if there is any new hearing that will commence, they will give them the day and time for it. The board may grant a hearing if it was not fair, if there was an error on the board's part, and the applicant has new and relevant information that can perhaps support this new hearing. It can also be reviewed by the same board that originally made the decision, but if it was due to an unfairness, then it would be done otherwise. Regardless, whoever does the hearing, they will have access to the prior decision granting the review unless it compromises the review hearing.